We are now live streaming to YouTube. Everything that happens is visible to the general public.
All right. Let me make sure. Good morning.
Good morning.
Good morning. Hold on. If y'all could just be sure that you're unmuted. Miss Burgess, I think.
Good morning.
Okay,
Does that work?
Good morning. Yes. And so I'm going to go ahead and call the case. And I understand, Mr. Spalding, that you are going to argue on behalf of the appellants, and Ms. Burgess, you're arguing on behalf of the appellees.
Yes, Your
Yes.
Honor.
Right. Okay. And this is the case of Stephen Painter et al. Versus Amerimex Drilling, case number 08-19-00226-CV. And just in case y'all haven't ever argued in front of us, with the advent of Zoom, we've elongated our times. So it's 25 minutes for appellant, 25 minutes for appellee, and 15 minutes for appellant. So it's a little bit of extra time. And the only other thing we don't have this morning is we don't have a timekeeper. So in lieu of that, what I'm going to suggest to y'all is, if you want to put your phones in front of you, and I will give you a 1 minute warning, and then at the end of your time, I will just say stop. All right.
Okay.
And with that, Mr. Spalding, you may proceed.
Thank you, Your Honor. Good morning, Chief Justice Rodriguez, Justice Palafox, and Judge Ferguson. May it please the court. I'm Thad Spalding. I'm here on behalf of the appellants, Stephen Painter, and the families of Earl Wright and Albert Carrillo. We're back. This case has been here before, and we're back, although we're back in with some important distinctions from the last time we were here. Importantly, the original Painter case, as the court is well aware, dealt with vicarious liability of J.C. Burchett, who was a driller in this case and the driver at the time the accident occurred. This summary judgment that was granted is the third one that's been filed. It's the second time Amerimex has sought summary judgment on the basis of the workers' comp exclusion. The first time it was denied, this time it was granted. And the workers' comp exclusion presents a different perspective on the facts as they pertain to course and scope. There's certainly some, as we learned from the Supreme Court in Painter, there's certainly some overlap between what the workers' comp law says and what the common law says. And there's not a significant amount of difference anymore. However, we do start with the general rule. And the general rule is that transportation to and from the workplace is not in the course and scope of employment. And that's what the passengers in this vehicle were doing at the time that the accident happened. They were traveling from the well site back to a bunkhouse that was in Fort Stockton. Now, under the statute, there's a couple of prongs. Some of the cases read it as three different prongs, but the first element is the court has to look at the nature of the activity and has to determine whether that activity, whatever the activity is, has to determine whether that activity relates to and originates in the business of the employer. And that's important because what we do know in the origination context is same thing I said just a few minutes ago, which is that the general rule is travel to and from work does not originate in an employer's business. And why is that? The reason that is because everybody, for the most part, has to travel to and from their job. And in doing so, you encounter the same risks that the general public encounters on their way to and from work. So there's got to be something more in order for travel to constitute to have originated in the employee's business. And part of the problem with these comp cases and the origination element is a very all of the cases determined, it's very fact intensive. And so you've got workers' comp cases and vicarious liability cases going back 60, 70 years with every possible permutation of facts. And what Amerimex has sought to do in this case, and really probably the reason that the summary judgment was granted in this case, is try and fashion a concrete rule. And in this case, they've tried to fashion that concrete rule out of the Seabright case from the Texas Supreme Court. And Amerimex has taken the position that, hey, these cases are on all fours. And so if they were in the course and scope for comp purposes in Seabright, they were definitely in the course and scope for our purposes here. That's not the case when you drill down, for lack of a better term, when you drill down, look at the evidence in this case and the particular circumstances in this case. So what we do know, let me back up a little bit, still kind of getting to what are the parameters we're working at, not looking at specific facts of different cases, but what are the general rules that we can glean from some of these cases. And one of them is that ordinarily, the general rule is that transportation to and from work is not covered. Now, under some circumstances, transportation that is provided by the employer can be, but it's got to be a necessity from the standpoint of the employer, and it cannot be simply the gratuitous provision of transportation as an accommodation to the employees. And in this case, transportation was not a necessity from the standpoint of Amerimex. Now, Amerimex, this was a unique situation for Amerimex. And Mr. Murphy, who was Amerimex's chief financial officer, testified regarding this driller bonus that was provided as part of the contract between Sandridge and Amerimex. As Mr. Murphy testified, this was the only time they had ever done this. This is the only time they had ever paid this driver bonus. And the reason that they did it was because Sandridge wanted them to. And
correct me if I'm wrong, Sandridge also negotiated or insisted upon that the bunkhouse, which Amerimex generally would put with the rig, that they insisted that it be placed off the rig, and so therefore it was in Fort Stockton.
That's correct. Amerimex,
and that's why Sandridge was paying that bonus to the driver in order to assist in helping transport his crew.
Well, that's a little question. That global position is a little questionable based on this record, because if you look at the testimony of Mr. Murphy, the bonus was being paid not so much to get employees back and forth to the bunkhouse, because Amerimex had never paid it before. Now, Chief Justice, you're right. Amerimex always had its bunkhouse on the premises, and Sandridge, in this case, Murphy testifies there were 30 to 50 different rigs on this property, and they made them put it away because there was so much traffic on this particular premises. So they move it away. But Mr. Murphy, and you can find his testimony, Amerimex cites to it at pages 15 to 16 of their brief, but you can find his testimony at the clerk's record pages 496 and 498. And what he says is, if they didn't pay the driller's bonus, these guys would just go work for another rig, because he said there's 30 other rigs out there. So this bonus was for them to be competitive, in Mr. Murphy's own words. So it wasn't required for them, or at least from Amerimex's standpoint, it wasn't required for them to get people to and from the well site. I mean, it certainly did that, but this was just from Amerimex's standpoint, this was not a necessity. They only did this because Sandridge insisted on it. And as Mr. Murphy said, if they hadn't paid it, these guys just would have gone to work for another crew that was out there in the same general vicinity. So given that testimony, we believe that establishes that this was that the provision of a vehicle, and keep in mind, this was Mr. Burchett's personal vehicle. Amerimex didn't provide him a company car. The only thing being provided to them was this, to him, to Mr. Burchett, was this bonus. Nobody else got paid for their transportation. Nobody else got paid at all once they were off the clock of their 6 p.m. to 6 a.m. shifts out at the well. So if we're looking at it as far as whether this travel was a necessity from the standpoint of Amerimex, the answer to that is no. And if the answer to that is no, then Coleman, Texas Supreme Court in Coleman over 60 years ago tells us that the merely gratuitous provision of transportation, to the extent Amerimex is even providing the transportation, the gratuitous provision of transportation is just an accommodation, and it does not constitute origination for workers' comp purposes.
Mr. Spalding, the crew at issue here is somewhat of a specialized drilling crew, and they're not local employees from the area of the drill site. These are crews that work together, and they're put at these temporary drill sites until a job is finished, and then Amerimex moves them somewhere else, correct?
Well, in this case, the only testimony is not that necessarily that these guys worked for Amerimex and traveled around to different sites based on wherever Amerimex told them to go. In fact, Mr. Burchett said that this was the only time he worked for Amerimex. He had worked on Sandridge sites before, but this was the only time he'd worked for Amerimex. And what Mr. Murphy testified to was that they didn't find these guys. This was Mr. Burchett, who was the driller and the driver. He lived over in Big Spring, and he's the one that found these guys. And Mr. Murphy said, that's the way it typically worked, because you have the driller. The driller wants to know who he's working with, and he works with people that he's comfortable with. So while Mr. Burchett may have worked with these guys on other well projects, there's no evidence that Amerimex had hired these guys on a consistent basis and was moving them around to different remote well sites. And I think that's a significant distinction from some of the cases, including Seabright, because in Seabright, that guy worked for Interstate Treating, and he lived in Rio Grande City, but their office was in Odessa. But all he did was work at remote sites, and they moved him around. And so part of his employment with Interstate Treating was, I've got a company car, and I'm going to travel to at least the vicinity where I'm going to be working on this particular job. My company's telling me I've got to stay in a hotel, so I'm going to go stay in a hotel, and they're paying it all for me. That's not the case here. And in fact, here, based on Mr. Murphy's testimony, there's a bunch of guys working in this area around Pecos and Fort Stockton. And in fact, his bigger concern was not paying what other companies were paying and somehow having his crew poached. So this was not a situation where he was concerned with necessarily getting these guys, not having a crew if they couldn't get transportation from wherever they were located.
So if they hadn't, his position was if they didn't have the free transportation from the housing camp to the job site, that he might have not been able to keep the crew because of that additional cost. Is that what I understand you to say his testimony was?
No, his testimony was that if they didn't pay the bonus, they would lose them.
Right,
And
but that's the driller driver. We're talking about the crew right now. We're talking about the crew passengers, not the driller driver. That was my confusion. So was any of that related in any way to the passengers themselves and the travel from the crew housing to the job site?
No.
Okay.
The employees, the crew members were not paid anything else. There's some evidence of a subsistence bonus in the Sand Ridge contract, but even Mr. Murphy testified in his deposition that he's not even sure that all of the crew members got that per diem bonus. So there's even fact questions with regard to whether they were paid any sort of bonus above and beyond just their wages while they were at the well site.
Yeah, and my understanding and reading that particular deposition is that they were responsible for cleaning. They were responsible, the bunkhouse, they were responsible for food and clothing. So, but the utilities were provided at the bunkhouse. Obviously it was 12 hours on and 12 hours off. So you think it's a fair conclusion that they were not provided a per diem and they were just paid for the 12 hours that they worked on the rig?
Yes, I think based on this summary judgment record, there's certainly not conclusive proof that they were paid any sort of per diem, because Mr. Murphy testified that he wasn't sure that they got him, and the only testimony is from Mr. Burchett that he was getting both the driller bonus and this other per diem. In fact, some of the testimony gets a little confusing as to which bonus he's talking about reimbursing him for paying for food and gas and that kind of stuff. So
and it seems like in looking at the depositions and reading some of the other oil and gas cases, that it's essentially Amerimex hires the driller. The driller has his team, which are the three roughnecks, which is his crew. And so they just come incidentally. They're not, like you said, they don't find them. And so once Burkett is hired, here's his crew. And so there's almost like, they're like a team. Yeah.
Yeah, and so from Amerimex's perspective, which we're looking at for purposes of this origination element, they, I don't know that they care where they come from as long as this guy brings a crew with him. Because if he doesn't bring a crew with him, then they're not getting the job done. But so, ultimately, the provision of, and this is all beside the fact that the evidence is very clear that they did not have to travel with Mr. Burchett. They did not have to stay at the bunkhouse. So to the extent they are providing anything to these crew members, it is purely gratuitous, which is not enough to constitute origination. And keep in mind that, we're talking about the summary judgment context too. So this is Amerimex's affirmative defense that they've got to conclusively establish. And on these facts and on this record, none of the case law is sufficient to conclusively establish as a matter of law that the travel at issue here originated in the very nature of Amerimex's business. And I think one of the cases that I think is telling, and it's an old case, and it's an old Fifth Circuit case, but it's cited by the Texas Supreme Court in Shelton, the Shelton case, Shelton was the case of the guy that was helping move a company back and forth, or from Wichita to Abilene, and he had to go to Dallas, and he crossed the street to get a sandwich and got hit by a car. Well, in that case, the court cites to the Rodriguez case, which is a Fifth Circuit case, 244 F. 2nd 484. And in that case, the court notes that where the employee has a fixed place of employment and a fixed job and is only paid for that time while he is on that location, that is not enough to put him in traveling to and from that job in the course and scope of his employment. That is really no different than any other employment situation where you have to drive to and from the site, to and from the workplace. There's got to be more, and Seabright notes that it's got to get to the point where you're more akin to a delivery man or a messenger or a courier, someone who is put on the street as part of their job. And so I think when you get to a situation like Seabright, where you have an employee whose job varies, and Judge Ferguson, you could have keyed on this a little bit, is when your job varies and you're going to remote places all the time as part of your employment, then it gets closer, and you can be subject to certain, controlled by the employer. It can be a necessity of your employment, but that's just not the case here, particularly on this record. So
you brought a distinction in Seabright that I don't see in the case, and I want to ask you to clarify or correct. Okay. You indicated that in Lopez that he was required, and the crew was required to use the carpooling back and forth during which the accident occurred. But that wasn't my recollection. I'm reviewing the case right now, and in fact, it says Interstate Treating allowed Lopez to use a company vehicle to drive and allowed the crew members to ride with him. But I don't see anything in this case that says it was required. Similarly to this case, in that case, it was merely allowed and encouraged through the benefit of the free travel from that particular location. So am I reading this wrong? In fact, was Lopez and were his crew members required to take the carpool from one location to another in Seabright?
No, Judge Ferguson, you're correct. If I said that, I was wrong. The part of Seabright that I recall being required was that he stay near the location of where he was going to be working.
This says he chose to stay approximately 40 miles from the site at a motel in Marlin, Texas. That's in the facts at the beginning of the case.
Right. That's correct. And he could pick the motel where he wanted to stay. My point being is that he could not go, the company would not let him drive home. So he had to stay somewhere close or somewhere in the vicinity of where he was going to be working. The company did not dictate where he stayed, or what hotel he stayed at or anything like that. They would reimburse him for his expenses. But no, you're correct. And I apologize if I misspoke on that. But yeah, my point was that he was required to stay near those jobs. And that was where the company imposed some obligation on him, unlike our case where the Amerimex employees were pretty clear they didn't care where our guys stayed. They could go home, and in fact, they did go home on occasion to, instead of staying at the bunkhouse.
Thank you.
So that distinguishes those two cases.
Mr. Spalding, I understand your argument from a general point of view, but can you again drill down then into the statutory language? And what is the path in which you reach that same conclusion that you're reaching, linking it to the plain reading of the statute?
So the statute first defines course and scope of employment. And it defines course and scope of employment as an activity of any kind or character that has to do with and originates in the work of the employer. And so that language is the first prong of the test. And that's just talking about the activity generally. Assuming they are able to prove that the travel was a integral part of their business, then you get to there's an exclusion. There's an exclusion for travel to and from work. And I think that, it just kind of confirms that the general rule I stated earlier, that travel to and from work, generally speaking, is not considered to originate. But it's kind of weird that you've got that as part of the first prong. And then the second prong is that travel to and from work is excluded, but then you have exceptions to those. And so the travel has to first be an integral part or a necessary part of the employer's business, because if you get to the exceptions—
1 minute warning. Sorry.
Thank you, Your Honor. If you get to the exceptions, the first exception is the first exception to the exclusion for travel to and from work is that the transportation was paid for by the employer or was a part of the express or implied contract with the employer. And if without the origination element at the beginning, which requires a more stringent, it has a more stringent requirement regarding the nature of the travel with regard to the employer's business. If every time an employer paid for transportation, then all of those cases would be, you'd find them within the course and scope of employment. Now, we don't think that's the case here. We don't think they can even get to the exception, but that's kind of where that exclusion and exception comes into play on the second prong of that test.
And your time is up, Mr. Spalding. So
Thank
you'll
you.
have a 15-minute rebuttal.
Thank you.
Ms. Burgess, you may begin.
You're muted is, I think, the national word or the annual word of 2020 and 2021. Thank you for seeing us virtually today. I wish I could be there with you. We really have to focus on Seabright. There is no meaningful difference here. That was a summary judgment case where the Texas Supreme Court found origination, which is the one element here on the Workers' Compensation Act that is in dispute because the plaintiffs have conceded furtherance. So origination is the only issue in terms of do they fall within the act. And then, as you pointed out, Justice Palafox, then there's the coming and going exclusion. And then there are exceptions to that exclusion. For instance, here that we paid for and furnished the transportation. Also, the court has already said, the Supreme Court has already said that we had control over that transportation. So it helps a little bit to back up and look at what this act is all about. This, as the Texas Supreme Court has explained, the Workers' Compensation Act it encourages employers to subscribe, like Amerimex did here, and it must be construed liberally in favor of coverage as a means of affording employees the protections that the legislature has created. Employees get the no-fault liberal coverage, and employers get a bar so that they don't have to face tort litigation like they have here. In this case, there's no question that Amerimax was a subscriber. It filed claims itself immediately upon this accident that, as you all well know, occurred between the remote well location and the bunkhouse. Unfortunately, plaintiff's counsel they opted to affirmatively waive those rights on the record instead of choosing recovery under the Act. Now, in most cases, the rules that you're writing in this case, in most cases, inure to the benefit of the covered workers' compensation claim. In other words, for instance, in Seabright, Mrs. Lopez, Mr. Lopez's widow, was trying to find coverage so that she could get those benefits afforded under the Act, the benefits that the legislature created. So the same rules that apply to an employer who wants to assert the bar also apply in most of the cases that we read to the decedent, to the beneficiaries or the comp worker himself who is applying to get that coverage. It's a two-way street. And the rules of the road apply whichever direction you're traveling on that road. And the rules of that road here are given to you conclusively in just two cases that are both recent and both from the Texas Supreme Court. If you look at Seabright and you look at Painter, you cannot get past those two sets of rules and get to a fact question, and you certainly can't get outside of the bar. The three questions that are before you today, because of the statutory scheme that Mr. Spalding spelled out for us, is whether, first of all, whether the travel originated in the employer's business. I'll elaborate shortly, but under Seabright, the Texas Supreme Court upheld summary judgment, finding that origination was conclusively established, and thus workers' compensation coverage was conclusively established under Sacramento. There's not one material difference between those and the undisputed facts and the findings of the Texas Supreme Court in this case. Regardless, you cannot draw an imaginary line between the front seat and the back seat. That's the Janik case that we've cited. There is case law going back to the Texas Supreme Court, 1964 in Janik, that says if the driver is in the course and scope, then so must the passengers be. And these are drilling cases. In fact, there's one out of this court from 1976 called Liberty Mutual Insurance Company versus Chestnut that I'll talk to you about in just a little bit. So you've got the origination element, and then you've got the question of whether the exclusion to the coming and going rule apply. Here, there's two ways that you get there. The first element is that transportation was furnished as part of the employment or paid for by the employer, or the transportation was under the control of the employer. Now we have, like I said, the extraordinary situation here where the Texas Supreme Court has analyzed these circumstances, these parties, and even this very trip. And this court has just analyzed that case again in the Rudolph case yourselves. Not only has the Texas Supreme Court told us the result on control, they've also set out established undisputed facts that could lead to absolutely no other result here than the workers' comp bar. One is that the accident, as you know, occurred while Burchett was driving the crew. And this is a quote from page 137. Amerimax was contractually required to pay a specific crew member, the driller, a bonus for carrying out a specific task, driving the crew between the bunkhouse and the drilling site. The trip benefited Amerimax by ensuring that the full crew showed up for each shift and was not left stranded on the site at the end of the day, and that the drillers were not hired away. And that's a concession that the appellants have had to make, is that we had to not just get Mr. Burchett there, but we had to get the whole crew there in order to get started. And you may have noticed in the record too, that we weren't allowed to just bring as many cars as we wanted onto the site. The surface ownership and the land ownership were split, but that's not a material issue here that changes any of the facts. But regardless, it doesn't matter what would have happened. They could have driven in a separate car. They could have stayed at a motel. That's all in the deposition that you've thoroughly read. The question is what did happen. And that's what the Texas Supreme Court told us on page 137 of the opinion in this very case. They said that the fact that Burchett could have chosen not to drive was irrelevant because they were in fact driving to the bunkhouse at the time of the accident. The court's not going to look at what could have happened. The court's going to look at what did happen in this case. And in this case, there was travel that was necessitated by the nature of the business. And that's what Seabright tells us. It's notable here, and the Texas Supreme Court talks about this right off the bat at the beginning of the opinion. Amerimex filed injury reports with the comp carrier the same day. Then it initiated proceedings to trigger those benefits at the Texas Department of Insurance Workers' Compensation Division. Contrary to the accusation from the appellants in the briefs, Amerimex did not fight workers' compensation coverage, and nothing in the record will show otherwise. The appellants waived those rights and even teamed up with Texas Mutual Insurance to argue and get us thrown out on standing so that we couldn't get them their workers' compensation rights. And so
on that workers' compensation, on the decision reached by the workers' compensation division, what effect, if any, does that decision have on us? You know, in which they, as an aside, I understand that they found that Amerimex had no standing, but they also found or opined that the passengers were not in the course and scope. So is that in any way binding on us? Is that a persuasive authority? What do you think?
It's neither of those. And in fact, the Texas Supreme Court said that the issue of the, that court, first of all, said you can argue that in the trial court, right? We're not going to find that here because you don't have standing to bring it, but they did make that dicta as well. But then the Texas Supreme Court said that the workers' compensation issue had not been addressed. It is not only is it not binding, it's flat out wrong in terms of the dicta. For one reason, because you can't have a different situation for the driver and the passengers. And I'd like to jump into that. And that's one of the reasons that sending this back on a fact issue, a second fact issue, is not viable and would in fact leave the trial judge with an impossible jury charge to give this jury. The plaintiffs have to acknowledge that Burchett was in the course and scope of employment because they have to in order to get a vicarious liability finding, right? They're suing Amerimex, they're not suing Mr. Burchett. And if Burchett is in the course and scope, then so too must these individuals be. I'd like to point the court.
Wait, Ms. Burgess, real quick, just a real fine point question. If the driver, which we're saying was acting in the course and scope during the time because he was assigned this duty to drive, what was the assigned duty to the passengers at that time?
Well, they didn't have an assigned duty, Justice. The issue is whether the travel itself was necessitated by the nature of the work. If you look at the statute doesn't say anything about the individual passengers, but rather talks about the activity. And then the court in Seabright takes that statute and interprets it and says, here's a quote from that. It says, the relationship between Lopez's travel and his employment, is so close that it can fairly be said that the injury had to do with and originated in the work, business, trade, or profession, and thus it was conclusively established that the travel, which is the activity that Mr. Spalding pointed out, the travel itself originated in the business of the employer. So it doesn't pick apart the individuals.
I know your answer. So this is the issue that I have, is that Mr. Murphy testifies that Amerimex did not dictate the passengers' comings or goings, and it was Sandridge. I just have a real difficulty. I mean, all businesses need their employees. If I'm opening up a McDonald's at 8 o'clock in the morning or whatever the case may be, I need all my employees there. I just fail to see how under these circumstances and Mr. Murphy's testimony, I fail to see how their employment, how the driving and the traveling back and forth to the bunkhouse originates with Amerimex. And so I guess my question is, why isn't the testimony of your chief financial officer dispositive?
It's not at all, Judge, because we still fall squarely into the Seabright facts. And there, if you look at Seabright and you combine that with the fact that you can't have an imaginary line between the front seat and the back seat, you can't get there. I'll tell you from this very court in Liberty Mutual versus Chestnut, the court said it was worth nothing to get the driller alone to the rig site. Rather, it's his benefits, and they mean the employer's benefits, flowed from the arrangement or plan of paying the driller and making it his duty to get the crew to the job site. The success of this plan and the participation of the crew in it placed them all on equal footing to entitlement to compensation. So those passengers could have,
So-
I'm sorry.
I'm sorry. Did you go ahead and finish your thought, but I have a question.
Those passengers were entitled to workers' compensation. The fact that they affirmatively waived it kept them from getting that, they could be in the court saying, we would like,
I think your audio is fading.
is this better?
Yes.
I think I covered my speaker with my papers. I'm sorry, Justices. This is classic
All right.
Zoom bad etiquette. But the passengers had every right to workers' compensation coverage. As a result,
All right. So I have this.
right to the
So
bar.
I have this question then, looking at it from the mutual contractual arrangement between the employer and the passengers. You're saying that the employer has a responsibility, or at least is furnishing this travel to the passengers. But you're also saying that the passengers have no assigned duty to ride in the vehicle and have the choice not to. And then they're also not being paid for their time. So I'm trying to understand, where's the mutual exchange of benefits between, ordinarily you're going to see both sides having that exchange.
Justice, the mutual exchange of benefits is in the Texas Workers' Compensation Act. So the act does not require that we pay those individuals or we made a deal with them when they came to work for us. Under the act, you'll see this in Seabright and in other cases. Under the act, well, actually this part isn't in Seabright, but you have 5 days to say, I want to opt out of workers' compensation as an employee. Of course, that never happened here. And so once they're in the Workers' Compensation Act, then we have to look to how the act defines origination. And the act looks to the activity, not to whether someone got paid. This dates back to the 1948 case of Ng, which the Texas Supreme Court quoted in our case and also in Seabright. I would recommend to the court, it's exactly like this. The passengers were nobody was getting paid for the time. The only thing they got was a mileage reimbursement. Back in Ng. The same is true for Lopez.
Even in Painter, the analysis then took that hard look at how you apply the analysis of course and scope objectively. And so from the point of view of the passengers, what are the objective factors that lead you to a conclusion that at the time they were acting in the course and scope of their employment?
The Workers' Compensation Act, which was not before the court in Painter. So in Painter, the court was reviewing it from a common law vicarious liability standard. Here you have to go to the Workers' Compensation Act, and that's where the bar applies, and that's where Seabright is controlling. There they said, and this is why Seabright and Amerimax are different than McDonald's, Justice Rodriguez, because those businesses, and this is a quote from that case, call for employing specialized non-local work crews in constantly changing remote locations on temporary assignments. The employer was doing that, just like is true here, and just like is true in Lopez, in Seabright and in Ng. Lopez wasn't paid for his time. Lopez had full control of where he wanted to stay. In fact, the dissent found that he was not within the course and scope under the Workers' Compensation Act because he did choose to stay in Marlin, 40 miles away. And the dissent said, hey, you could have stayed much closer. There were other motels, but you chose to stay in this really remote place. And so your travel wasn't actually dictated by the nature of the business. Here's the travel. It's really important that the statute doesn't talk about who's doing what. Unlike vicarious liability course and scope, where you do have to do that analysis of the individual and objectively look at what the facts are. In Seabright, what the court says is the ultimate inquiry is whether the relationship between the travel and the employment was so close that it can fairly be said that the injury had to do with and originated in this in the employer's business. And there can be no question under the facts of Ng and under the facts of Seabright that that is true here. You could also look at the Pesqueda case, exactly the same. I mean, these accidents happen coming from remote job sites to these bunkhouses and other temporary shelters. And that's why the Comp Act is there. Justice Rodriguez, that's why the Comp Act doesn't pay for you to go home from your job at McDonald's. Yet it does say when the travel itself is necessitated by the nature of the work, like it is here, and it's provided for by the employer, then you're going to be within the Workers' Compensation Act. That's why Mr. Lopez was within the Workers' Compensation Act. That's why Mr. Ng was within the course and scope under the Workers' Compensation Act.
Talk to us a little bit about the fact, and Mr. Murphy made this, I think, very clear, is that Amerimex did not pay for the transportation, and that the drivers they would do some kind of bookkeeping or accounting, and then they would invoice Sandridge, and then once Sandridge paid Amerimex, then Amerimex would forward that money to the drivers. And so his position was Amerimex never paid for any of this travel. Now I understand that Mr. Burchett got a check from Amerimex, and that's a check he cashed. But when you say it's paid for by the employer, I mean, that deposition makes it very clear that their chief financial officer of your company said they did not pay for transportation and they weren't responsible for it. And if Sandridge didn't pay them the money, they weren't going to pay their drivers.
Justice, the statute says nothing at all about being reimbursed. In fact, if you were going to take that to its logical conclusion, all of our drilling costs were reimbursed by Sandridge. So yes, labor was also reimbursed by Sandridge. Everything, Sandridge contractually required Amerimex to pay for that travel and to furnish that travel. Certainly we cannot say that the workers themselves provided their travel that day. We can't say that Burchett provided their travel that day. He was paid by Amerimex, and Amerimex was reimbursed. That's not a fact question. We have, but there's case law, including the Bushman case out of San Antonio that we cited, that gives, for instance, when an individual is using his own car and gets reimbursed, that still falls within the exceptions to the coming and going rule as a paid for transportation, and that's true here. I want to note on Seabright, the argument that you've heard about necessity, the word necessity is not in Seabright. The word necessity is not in Ng. The word gratuitous does show up because the defense tried to argue it in trying to avoid workers' compensation coverage. And because he wasn't required to have a truck and he asked for a truck and they gave him a truck, still that was not enough of that's the same sort of fact issue that you might come up with in the reimbursement. And yet that wasn't enough to create a fact issue that was material. The other issue, the other kind of fact issue that the appellants would like to raise is this per diem question. And it's just a complete distinction without a difference, because no matter who was paid a per diem, just without taking, you don't need to know the facts on that. The facts are immaterial in that regard, because there was no per diem in Ng at all. That didn't matter. All it was a 7 cents per mile. It was 1948, 7 cents per mile reimbursement on the driving. And Seabright specifically talks about the per diem being to offset lodging. Well, here we gave them the lodging. And so they get the travel, they get the lodging. And so they're covered within the provisions of the Texas Workers' Compensation Act there. Amerimex, it's undisputed that Amerimex paid for both the travel and the lodging. the fact is that you just absolutely cannot distinguish Seabright. That business required the employees to stay in the temporary housing. The business required employees to stay in temporary housing. It wasn't Seabright that required something specific. The same is true here. Seabright
But
didn't.
Amerimax doesn't require the crew members to stay in the bunkhouse.
Absolutely not. They can stay anywhere they'd like. And that's one of the things that the Texas Supreme Court said. We're not looking at what could have happened. We're looking at what did happen. And the court made that very clear. They're going to analyze this from what was happening that day. And they were undisputably traveling from the remote work site to the bunkhouse.
I'm concerned about taking that one sentence in Seabright out of context, because the sentence is that Interstate's business required its workers to obtain temporary housing and travel from the housing to the site. Taken out of context, it sounds like they said, you must stay here and do this. But what they're actually saying in that case is, because these well sites are so remote, in our case, 30 miles, I think in that case, 31.5 miles, but whatever it is, these are remote locations. The very nature of the fact that we're going to take people who work and live in one place and ask them to go out to that site means you have to get a temporary place to stay. It's not that, for example, if someone lived 5 miles away from the site in Seabright, there wasn't an agreement from Interstate that said, now you have to get temporary housing 10 miles away because you have to be in temporary housing. Their whole point was you have to go to the site so that you can effectively get there and home every day. And so, yes, I mean, that's a distinction in the language of the case, but do you think that's a factual distinction here between Interstate saying you've got to live closer to the site and in our case where Sandridge says we're going to give you a place to stay, or Amerimex, we're going to give you a temporary site, stay there and we'll drive you back and forth?
Absolutely not. It's not a meaningful or material distinction. Not only has the court told us not to look at hypotheticals of what you could have done, but what you were doing. But secondly, it is exactly as you said, the nature of the work that necessitates the remote. It's the nature of this remote work. What we need from the court. Thank you, Judge.
Just 1 minute warning. Sorry, go ahead.
Thank you, Justice. What we need from courts like you, and what the Texas Supreme Court gave us back in Ng, where people were driving 450 miles from their houses in Big Spring to go work in Pecos and staying in Fort Stockton, just like they're doing today. What the court gave us was a bright line rule. And they reminded us of that bright line rule in Seabright. And they said, if that travel is necessitated by it actually originates in the business of the employer, and that travel is furnished by, paid for, or controlled by the employer, which there's no question it was all of those things in this case, then that is going to be within the Workers' Compensation Act. And they need that bright line rule so they know which is it Texas Mutual that's on the hook? Is it the carrier is it the employer who's on the hook? What is it? This is a type of work that necessitates these, what they, as you all know, man camps or bunkhouses, and thus it necessitates the travel itself. It separates it from our travel to and from our normal work every day. Thank you so much for your time.
Thank you. Your time is up. All right, Mr. Spalding.
Thank you, Your Honor. I take it from that argument that the position now, and I don't think Seabright supports this, but the position now by Amerimex is that work at any remote location, travel to that remote location is always going to fall within the course and scope of the employment. And that is not what Seabright says. And in fact, Seabright acknowledges that you have to look at the particular business and what they're doing and whether the travel is an integral part of the work that is being performed. And what we do know from the history, and there's a long history of workers' comp cases in either in the comp context or course and scope cases, either in the comp context or the vicarious liability context. What we do know is that just being out on a remote location is not enough. There's got to be more to it. And Seabright acknowledges that this was the nature of Interstate Treating's work, or at least the work that they were having Mr. Lopez perform, is he didn't come to the office in Odessa. You know, he was assigned to remote locations, to various remote locations. On this record, the Amerimex work was a one-off job. These guys were hired to come to the well, and they were only paid while they were at the well site. So when they got there, they started getting paid. When they left, they were no longer paid. Amerimex didn't care about the transportation. They were paying a bonus to a driller who would provide transportation. And it was his responsibility to take anybody that wanted to back and forth from the bunkhouse. But the crew members were not required to stay anywhere in particular. They could stay wherever they wanted to. And on this particular job, and if you look at the Fifth Circuit case in Rodriguez, where the employee was in Del Rio, or he was from San Antonio, he was working in Del Rio, and they required that he stay in Del Rio for 4.5 days out of the week. They said because his job was at a fixed location and he was paid just for the time he was at that job, then the travel to and from that, even to and from San Antonio to Del Rio, that did not fall within the course and scope of his employment, because we've got to have the general rule has to be acknowledged here. And I think Justice Rodriguez, you keyed on this, is that what Amerimex is arguing for is an exception that basically swallows the rule in any of these kind of situations. And it's an exception that travel to and from the work site, it's always going to fall within the course and scope of employment. There's a crucial distinction, and I disagree with Ms. Burgess on her interpretation of Janik. Janik is a dual purpose case. Janik is not our situation. Janik dealt with a situation where the driver and its crew members were were going to get ice for their job, and so they had varied from their ordinary route. They were on and the court determined that in going to get this ice, they were doing a task for their employer. They just weren't. It just wasn't going to and from work. And in that situation, they said it doesn't make sense to draw an imaginary line between the driver and the passengers, because the passengers are going to be part of that dual purpose too. And so we're going to lump all of them together. That's not the case here. You can draw a line. And in fact, the painter does draw a line. You know, the line is, it doesn't expressly draw a line between the driver and the passengers, because the passengers weren't at issue when the Supreme Court dealt with the vicarious liability of Burchett. What it did focus on is the fact that Burchett had a continuing obligation, a continuing duty on the part of his employer to transport employees. The fact that we're in the workers' comp context does not make a difference. This is not a benefit that any of the cases take into account in determining whether travel is a necessary element of, or falls with necessary element of the employer's business, and therefore falls within the course and scope of employment. And the employee, you know, my clients didn't waive their right to benefits. They were of the opinion, and they always have been, and we still are, that we aren't entitled to benefits under workers' comp because we weren't in the course and scope of our employment. So that's why, if you look at the workers' comp decisions, which I think are persuasive, they're not binding, of course, but they are persuasive, because workers' comp appeals panels look at these cases all the time. And not that this court doesn't also, but I think the workers' comp appeals panel looks at it a lot more than others. So I think it is persuasive when an appeals panel looks at these particular facts, and even the appeals panel drew a distinction between what Mr. Burchett, the driller, was doing and his passengers who were not get paid for any of their time and who were not obligated to stay at this bunkhouse. Ultimately, real quick. So the fact that Amerimex wants to lump the two together, that legally, that falls apart. Janik doesn't support it, and Liberty Mutual doesn't support it. In the Liberty Mutual case, you had the crew members were, the transportation was a part of their contract for the passengers. So there's a distinguishing feature in Liberty Mutual as well. But neither one of them stands for the proposition that you cannot differentiate between a driver who is paid and is obligated on behalf of the employer to drive crew members back and forth from the well site, from crew members who are not getting paid, who are not getting reimbursed, and who have no obligation to drive with the driller or stay in the bunkhouse and are not getting paid once they step off the premises.
Mr. Spalding, that recitation of facts about the crew members is exactly the same recitation of facts in Seabright. Isn't that correct? It's exactly the same. They weren't required to stay there. They weren't required to drive. They weren't paid to go. They weren't on the clock, and they weren't reimbursed. So there's no distinction between those two groups based on what you just said as the distinguishing characteristic. So, and by the way, it also doesn't say in Lopez and Seabright, it uses the word enabled by the benefit, enabled by providing per diem, or in our case, $50 for the trip. Isn't that kind of what we have here? We have crew members, they're not paid to travel, but they're taking the trip, or what they call the carpool in one of the cases, is enabled by the fact that the only way they get free travel to the job site and back is if they go to the crew camp and ride with their driller.
Okay, first, Judge Ferguson, first of all, with regard to Seabright, an important distinction, I think, and I agree with you that there was no requirement, although they were required to stay near the remote site, which is not the case here. Seabright did not address passengers. So if we're drawing a distinction, the passengers were not at issue in that case. Seabright involved Lopez, who had a company car and whose job it was to go to these remote locations and complete the work. And he did it on numerous occasions. This particular one, at least my reading of the opinion, seems like it is consistent with what his job was throughout his time with interstate treating. You know, the passengers in that case, we don't know about the passengers in that case. There were passengers there. We don't know if they were from, the area. We don't know what we don't know whether they were required to stay nearby or how they came to be. And so the facts between the two are distinguishable. With regard to the transportation, yeah, they could take the transportation and they got free transportation. But what we do know from a legal standpoint is merely the gratuitous provision of transportation is not enough to put the travel to and from work in the course and scope of employment for origination purposes. And, part of the problem with these cases is they kind of bleed, you bleed an origination. And I think this gets to Ms. Burgess's argument where I think she wants to make travel to and from work both an exception to the exclusion and part of the origination in the employer's business, which basically swallows the entire rule and completely ignores the distinction between origination which must mean something different than and must require a higher standard for establishing that travel, what we're talking about here, is a necessary part of the nature of the employer's business. And I think if you look at Murphy's testimony in that case, in this case, they were not concerned with not having a crew or not being able to get these guys out to the area because of transportation. Their concern, and this is the summary judgment context, and this is where fact issues arise. Their concern was not paying the same bonuses that other guys were in the same area. So it really had, if you're looking at conclusively establishing, like Amerimex wants to do here, conclusively establishing those facts, that hasn't happened here. And it's important to note too that in Seabright is a summary judgment case, but it was a cross motion for summary judgment case. So you've got both sides moving for summary judgment. And, in the cross motion context, my thought is, everybody's agreeing that here's what the facts are and we just need to apply the law. That's not the case here. It's their burden to conclusively establish these different elements of the course and scope test, and they haven't done it. And so I'm not sure exactly how much time I have left.
A little over 2 minutes.
Okay, great. That gives me time to, I want to point out one other thing, and that is there seems to me to be a fundamental issue with Amerimex's argument. They want to put Burchett and the passengers in the same category. What we learned from Painter, and there are some statements made in Painter that are instructive, but the ultimate takeaway from Painter is that there are fact issues. And there are fact issues that prevented summary judgment from being granted. And that's the Supreme Court reversing a summary judgment in the course in a vicarious liability course and scope context. I don't see Amerimex stipulating here or anywhere that Mr. Burchett was in the course and scope of his employment. And so if they're not going to stipulate, so presumably when we go back to the trial court, Amerimex is still going to be arguing that Burchett was outside the course and scope of his employment. And if they're going to do that, how can they at the same time argue that they have conclusively established that our crew members were inside the course and scope of employment? Amerimex can't have it both ways. There are fact issues. The law does not support the conclusive establishment of their defenses. And we'd ask that this court reverse the summary judgment that was granted and remand this case for trial.
Well, thank you very much, counsel. We will take this case under advisement and hopefully get you an opinion as quickly as possible. But we really appreciate your participation. You've illuminated a lot of issues for us, and we'll deliberate. So thank you.
Thank you, Your Honor.
Bye-bye.